Good morning, good afternoon, or good evening, depending on where you are in the world, and welcome to Finnegan's webcast, How to Avoid Common IP Pitfalls in Energy Industry Joint Ventures and Collaborations. I'm Matt Halinka, and I'll be your moderator today. Before we get started, I invite everyone to participate by submitting questions. This is an interactive webinar. Just click on the red Q&A button at the lower center of the webcast interface and type your question into the Q&A window, then click Submit. Questions will be answered today during the question and answer session, which will take place at the conclusion of the presentation. You may enlarge the slide window at any time by clicking on the green Enlarge Window button on the top right side of the slide window. Slides will advance automatically throughout the event. If you are experiencing any technical difficulties, please click on the yellow Webcast Help Guide button in the lower center of the webcast interface. And with that, it is my pleasure to welcome our excellent slate of presenters today, Krista Bianco, Charles Collins Chase, and Jennifer Rossetti. Krista Bianco is a partner in Finnegan's Washington, D.C. office. Krista's practice is focused on contentious patent and contract matters before federal district courts, the PTAB, and appellate courts involving a wide range of chemical and pharmaceutical technologies. Charles Collins Chase is a partner in Finnegan's Washington, D.C. office. Charles uses his background in chemical engineering to provide particular expertise to companies looking to protect innovations in energy and renewables, chemical products, and pharmaceuticals. Jennifer Rossetti is also a partner in Finnegan's Washington, D.C. office. Jennifer's practice encompasses a range of technologies primarily focused on chemical subject matter, such as pharmaceuticals, cosmetics, and specialty chemicals. Krista, Charles, and Jen will share their experiences and best practices for protecting IP rights in joint ventures and other collaborations, as well as practical tips for avoiding common IP pitfalls. This is an especially timely presentation, as joint ventures and other collaborations between companies are becoming more and more important across the energy sector. In a recent survey of oil and gas CEOs, half of them said they expected to form a new joint venture in the next year. Joint ventures can come in many shapes and sizes and serve a variety of purposes. In that same survey, 57% of CEOs reported already working collaboratively with competitors or that they would consider doing so. For example, competitors Royal Dutch Shell and ExxonMobil formed the joint venture Infinium to collaborate on the formulation, manufacturing, and marketing of petroleum additives for lubricants and fuels. The Dutch life sciences company Royal DSM has formed a joint venture with Roccat, the French starch and starch derivatives company, to develop a sustainable fermentation technology for the production of bio-based chemicals. Vestas Wind Services and Mitsubishi formed a joint venture that combines Vestas's technological know-how with Mitsubishi's financial backing to compete with Siemens in the offshore wind marketplace. And Eastman Chemical and Sinopec Petrochemical Company have formed a joint venture to build a hydrogenated hydrocarbon resin plant in China and to expand Eastman's footprint in Asia. There are also many different ways for companies to collaborate. Some are very informal, while some create a separate entity, like the ones I just mentioned. Forming a joint venture can have a number of benefits. It can spread the risk when embarking on an unknown or expensive new project. The joint venture can help to spread out capital costs. Joint ventures can be used to gain access to technology. A joint venture can also be a great way to share ideas and combine different areas of technical expertise. Two heads are often better than one. They are often used to gain access to resources and new territories and markets. And in some instances, the political climate might require a joint venture with a local company to gain access. Regardless of the goal of the joint venture, the benefits sought, or the degree of formality, there are at least some things that both parties should be conscious of, especially as it relates to intellectual property. Some of the risks include the loss of trade secrets and know-how transferred to competitors and partners, and uncertainty over the ownership and enforcement of IP brought to the joint venture and created through the efforts of the joint venture. In this webinar, we will discuss best practices for protecting IP rights in joint ventures and other collaborations, as well as practical tips for avoiding common IP pitfalls. And now I will turn it over to Krista to talk about pre-venture considerations.
Thanks, Matt. It is important to give thought before you enter into a JV or other collaborative agreement as to what is the goal of the collaboration. Matt talked about many of the benefits and risks of JV, and you want to make sure that any agreements you enter into as part of that collaboration adequately anticipate and govern the collaboration. For example, you would want to consider what product, process, or service is to be developed. Where will that product, process, and service be developed and sold? Is the development an improvement to an existing product, process, or service, or is it something that's going to be newly created stemming from the joint venture? Who is responsible for what aspect of the research, as that may define what IP is being contributed and what which each company is bringing to the table. You also would like to consider the potential bounds and limits as to what may be permissible under the collaborative research, because you want to help protect against mission creep, which can have unintended consequences not anticipated by the agreements that are entered into at the beginning of the collaboration. Another important consideration is to consider what is your relationship to the other potential parties to the joint venture. For example, if the parties are a direct competitor in certain markets, then that may impact how you may seek to protect your trade secrets, as we will hear later in the webinar from Jen, or license certain IP as part of the joint venture. You also want to give some thought to what are the corporate entities associated with the other potential partner. As I will talk about in a few minutes, to the extent you grant IP rights to your partner, do you want those rights to extend to subsidiaries or related companies, newly acquired companies, or spin-offs? There's no right or wrong answers. These are just things that the parties you want to fully consider before you enter into agreement so that you can account for those situations in the agreements. When considering entering into a joint venture or collaboration, one of the first steps would be to enter into a non-disclosure agreement, or NDA. An NDA will allow the parties to share at least some of their respective knowledge and expertise, and also would permit each side to determine whether the collaborative relationship is indeed desirable and beneficial. A common provision to the NDA would prohibit the disclosure of non-public information obtained from the other party, but you can also prohibit disclosure of the possible collaboration itself if it doesn't want knowledge to be in the public that certain companies are collaborating. You may also want to carefully consider who on your team should have access to the other party's confidential information in the negotiation stage. On one hand, you may want to give access to those employees who are knowledgeable about the technology so that the company can reach the best business decisions in deciding how and whether to enter into a joint venture. But there can be risks in giving access to an essential or extremely knowledgeable employee. One risk is if that person has a lot of technical knowledge, that is knowledge that the other parties may be able to potentially learn during the negotiation stage or the collaboration stage. A second risk is that the designated employee may become contaminated. For example, if the main goal of the collaboration is a technology acquisition and the confidential information includes underlying know-how on how to carry out or practice a technology, it can be difficult for that designated employee to unlearn the information he learned from the other company or to be firewalled off from subsequent projects if that is necessary. Another important consideration that you want to give thought to, and that I've talked about already, is who is your partner and who are the other corporate entities that may be associated with your partner. So for example, if you're going to license background or contributed IP, who's going to have rights to practice that patent, that technology? You want to make sure that your JV carefully lists who has rights and also potentially accounts for future changes in corporate structure or ownership. Why is this important? Imprecise drafting can help your competitors. For example, in Technology Licensing Corp, the JVC Americas Corporation, a case out of the Northern District of Illinois, that dealt with a situation where a patent licensee ceased to control a former subsidiary. And the question at issue in that case was, does that subsidiary have a license to practice the patent even though it is no longer controlled by its parent? And the court said yes, that based on the definition of subsidiary in that agreement that the parties entered into, the agreement gave rights to any company that was a subsidiary at the time the contract was executed. And so since the subsidiary was a subsidiary at the time the contract was executed, it had a license to the patent. The court also looked at in the rest of the agreement and said there wasn't anything in the agreement that suggests that a subsidiary could lose its rights under the agreement upon ceasing to be majority owned by one of the parties. So because the court found that, in fact, the subsidiary did have a license under the agreement and that you could not lose your rights, it did not infringe the patent at issue in that case. Another important thing after you have the NDA and you've considered your party, you'll want to conduct due diligence. And among the diligence you would like to conduct is you may want to conduct a freedom to operate. That analysis is helpful to know what other companies are doing and where blocking patents may exist that may threaten the rights of the joint venture or collaboration to practice what they want to do. For example, you could, and also these are important considerations that you may need a contract for and anticipate as part of the collaboration. So for example, what do the companies want to do if a third party out there potentially has blocking patents? Would the joint venture want to invalidate or carve out a design around to those patents? Or is it necessary to get a license to those patents? And if it is necessary to get a license, which party assumes the cost for any licensing obligations? Or potentially, maybe if there is other blocking patents out there that's going to prevent the joint venture from achieving what it would like to achieve, maybe you just want to walk away from the collaboration. These are all information and considerations that a freedom to operate could give you additional information on. The other due diligence you'd want to conduct is looking at the title and inventorship of IP to be contributed to a joint venture. You want to know the existence of any IP co-owners and if there's any uncertainty over the rights that are being contributed to the joint venture. For example, you'd want to verify ownership. Has the other party investigated who the inventors are on the patents and whether any work that contributed to that patent was done outside the company? Can the other party produce assignment and employment agreements from its inventors? Do those employment agreements include clauses to assist in prosecution and litigation involving IP as allowed by local law? Do those employment agreements include agreements not to compete as allowed by local law? You may want to include a warranty or indemnification clause for protection in case of invalidity of a patent due to incorrect title or ownership. You also would want to look at and identify any encumbrances against the IP that could affect the rights conveyed to the JV. These can include security interests and pre-existing licenses to other parties, for example. You also may want to look at, are there any weaknesses in the IP that can affect the JV's ability to exploit it? For example, are the claims of the contributed IP very narrow, such that they wouldn't cover the product that's at subject or at issue during the joint venture? Or is the patent easy to design around, such that there's substitutes or somebody can easily get around it? These are all things that may impact the type of license or what value is attributed to the background IP, and that's something that a due diligence can help shed light on. Also, I'll talk about in a moment, but you can also, the diligence you do, you can also backstop that diligence with representations in the joint venture agreement. So turning now to, you've decided we are going to enter into a joint venture and there's IP contributions that need to be made to the joint venture. How do you define those and how do you protect those? At the outset, it's common for the parties to disclose and later contribute or license IP to the joint venture. Potential IP contributions can include pre-existing IP owned by the contributing party, which is often called background IP. It could also include third-party IP, any licensed IP rights that a party or the joint venture may obtain rights to. It can also include trade secrets, and it can also include other know-how or resources and capabilities, such as scientific materials, facility access, or know-how. It's important to understand and define in the agreement what is being contributed, and it's also equally important to understand and define what is not being contributed. It's also common to include a no guarantee of success clause to protect the contributing party from claims that the contributed IP did not fulfill the intended purpose. As I mentioned, you would also want to include in the agreement some diligence representations. These representations are commonly that the contributing owner is the sole and exclusive owner of the IP, there's no encumbrances, the contributed IP does not infringe third-party rights, there's no patent maintenance fee lapses, the patents are valid to the person's knowledge, there's no breach of any licenses or other agreements related to the contributed IP, and that the developers or the inventors have assigned the IP to the company and owner. How do you contribute startup or background IP to the joint venture? I mean, you want to make sure, the companies obviously want to make sure that both parties have access to the IP and the know-how necessary to succeed in the joint venture. And whether an assignment or license is appropriate for patents will depend on the circumstances of the JV and the owner's plans to use the IP in connection with the JV or for other purposes. Typically, assignments are generally done where there's going to be a separate legal entity, an LLC, for example, that will govern development of joint IP. If you assign a patent, then you will, if one company assigns the patent, then they will no longer have any ownership rights to that patent and may need a license back to be able to practice the technology that is in the patent. But if a party wants to generally hold on to its IP, then you would want to consider the appropriate license provisions. And those provisions are listed on this slide. A non-exclusive license is simply a promise not to sue the other party for what would otherwise be patent infringement. The licensee would get no protection from unlicensed competition. The licensor may grant other licenses to other parties, and generally the promise not to sue will run with the patent. So if it is subsequently licensed to another party, that license will continue. An exclusive license is a promise by the licensor not to grant future license. And also the licensor would not be permitted to practice under the licensed patent unless there's a reservation of rights. There's other restrictions you can put on the license even if you decide to grant an exclusive license. For example, field of use restrictions are commonly used if the patented technology covers a range of products or uses, and only one category of products or uses is necessary to be contributed to the JV. You can also include geographical restrictions. If the joint venture is relevant in one country or one market, the license can be limited to that country or market, and the patent owner can keep the rights in the other countries that are not where the JV will be focused. Typically, too, if there's a license to the patents typically, the license will extend to pending or future patent applications. However, that's something that can be changed by contract if the parties want to do so. It's just an important consideration to consider. Charles will be talking a little later about who would own any improvements of the background or contributed IP, but that's something that is usually addressed in the agreements as well. And you can also address royalties. For royalties, typically there may not be royalties during the collaboration, but the parties may want to negotiate what, if any, royalties would apply after the collaboration ends. You also would want to consider and contract for what happens to the IP rights after the collaboration ends. What are the rights and obligations of each party? Termination provisions are commonly a hotly negotiated issue, particularly when the contributed IP is core to the joint venture's business. And pre-negotiation of royalty and termination provisions prevent the IP owner from having unfair leverage or basically holding the other party hostage once the collaboration ends. Another important consideration for startup or background IP is what party can enforce that IP. For patent rights, the type of license and any restrictions on the granted license impact whether the licensee must join the patentee if the licensee seeks to enforce the licensed patent in court. Generally, an exclusive licensee must join the patent owner, and courts have generally held if there are field of use restrictions, then the licensee does not have all substantial rights in the patent and must join the patent owner. Another important licensing consideration is You want to identify, as I said, what IP is being contributed, but it's equally important to define what is not being contributed. So you don't want to give, because of ambiguity, give an implied license to IP that is not intended to be contributed to the joint venture. So your agreement would also want to clearly define any IP that is not being contributed and specify whether or not any license to such IP is granted. It's also common to include the requirement in the agreement that neither party, the joint venture, nor any third parties may use another party's underlying contributed IP independent of the joint venture. For example, it's pretty common to, especially if it's mainly patents involved, to include a list of all background IP that's being included in the agreement. And therefore, it's clear what's being included, contributed, and if it's not on that list, then it is not being contributed. With that, that ends my portion of the presentation. I'm going to turn the presentation over to Jen to talk about protecting and maintaining trade secrets.
Thanks, Krista. I'm happy to cover the trade secret portion of today's presentation. We'll start out with the first point, just to remember that just because we are in a collaborative setting with respect to joint ventures does not mean that all parties may not pose a risk to the trade secrets. In general, most people know that trade secret theft is on a high rate, especially in the U.S., and it's an estimated $300 billion loss in the U.S. alone each year. The question, though, is who is it that poses the risk to trade secrets? And while focus may be on actors that are pictured here, that are seen as unwelcomed outsiders, and you'll be focused on providing physical security, it is actually more likely that it's those people seated around the table during your negotiation for the joint venture. The statistics say that the vast majority of trade secret misappropriation is either by an employee or a business partner, focusing 90% of the federal cases and 93% of state cases. So in fact, the most substantial risk to your trade secrets could be those that you believe will be your future partner. So when entering into negotiations for a potential joint venture, how do you protect yourself and the trade secrets during the whole life cycle of a joint venture? And that includes during negotiation, if you reach agreement, during the actual life of the joint venture, and then also once it ends, how do you protect yourself once you are no longer partners with the other party? Most people don't necessarily contemplate that their obligation and due diligence needs to continue after the end of the relationship. So we're going to talk about all different cycles today and what you need to do to protect your trade secrets. Just to start out with the basics, again, a trade secret is really any useful information that's not generally known or readily obtained, and it actually gives its owner some sort of competitive advantage. And to qualify as a trade secret, it's important that the owner take reasonable precautions to ensure that that information remains secret, because if it becomes public, then of course it's lost forever. So the first step with respect to protecting your trade secrets, of course, is to internally identify any trade secret that may be implicated by a potential joint venture. And while you probably already have some policies, procedures in place, it's definitely good practice to go through the task of first identifying those trade secrets in anticipation of any negotiation for the specific JV of interest. So how do you go about doing that? Again, the focus is to determine where you have commercial advantages over your competitors. And when I say competitors, that includes your potential partner, even though you may ultimately enter into an agreement. And these are usually areas where you have the advantage or sources of revenue. And most people think about first the technical information. So your processes, formulas, ingredients, maybe you have a particular machinery design or specs that cause you to have that competitive advantage, or perhaps it's sourcing of particular material components in your process, or experimental, and of course your R&D. What some people forget about to include in their analysis, and certainly in the collaboration aspect, is the financial information that's really giving them the competitive advantage that may be driving the need for the joint venture in the first place. And that includes things such as cost of goods, supplier identities, pricing models and discounts, and certainly any distributor and dealer discounts. Other information can include things related more to marketing and sales, so new product development, and certainly if you have a plan for particular geographical penetration, which may ultimately be divided up between your joint venture. So what should the joint venture agreement actually include? First, we've got here identify any trade secrets. So that's the first step we've just talked about. And doing that internally before you get to the negotiating table and before you start exchanging information, even pre-joint venture. And certainly detailing the ownership once you've reached that stage and acknowledging the value of the information. All of these things are helping to set out and prove that, in fact, what you have identified is a trade secret. And finally, to specify the confidentiality measures. This goes back to the point that you must take reasonable measures, and certainly if you get into a dispute later, the court will look at what reasonable measures that you took or anyone else that had access to your trade secret to protect. So you need to look at the policies that you have in place and make sure in whatever agreement that you're entering into that it's clear that those policies are expected of your partner. So this includes things like confidentiality agreements for third parties, computer security measures, or even having your potential partner certify regarding the return or destruction of all the confidential information once the JV ends. And this can protect yourself as well. You also may want to have your partners actually acknowledge ongoing confidentiality obligations through the life of the joint venture. Again, this is all going to showing reasonable measures to protect a trade secret. Now, all that to say, as far as treating your joint venture partners, certainly you are a partner, but at least in the initial stage and actually throughout the life cycle of the joint venture, to treat them like a third party for purposes of trade secret protection. And the Wellogix case is a great example of why you can't just rely on trust when it comes to partnering up, even though you may have a great relationship, and certainly the industries we're speaking to today in our experience certainly do. But as with any relationship, sometimes things can go wrong. So in the Wellogix case, they had developed a complex services software that was targeting the oil and gas industry. Now, in order to promote that software, Wellogix entered into several confidentiality agreements, which is a good thing, which is what we have been identifying as one of the steps that you need to take. And they did that with Accenture, and they launched a pilot project also with BP. So subject to those agreements, they then shared the source code and access to the technology with both Accenture and BP. But because of certain things, including cost and internal integration issues, BP discontinued its collaboration and instead asked Accenture to develop a similar complex services software. So you can guess what happens next. In its lawsuit, Wellogix alleged that Accenture had stolen and misappropriated Wellogix's trade secrets while creating their own version of complex services software. So basically, when they got cut out, they started to suspect some sort of issue. Now, Accenture argued that Wellogix's software did not contain any trade secrets, but thankfully for Wellogix, the court held that they did have trade secrets, and they based it not on any specific thing in an agreement, but rather the reasonable efforts to keep the information secret. And that resulted in a $44 million trade secret award for them. Now, those types of efforts to keep it secret include keeping the data behind a firewall and also those confidentiality agreements, which were two of the things that we identified earlier. So the lesson learned here for Wellogix is definitely don't rely on the court to make the leap for you on sort of circumstantial evidence, but rather rely on a comprehensive agreement and certainly to spell out those trade secrets and identify them. Now, you may say, there's some sort of tension here by saying that you need to identify all the trade secrets in the agreement itself, and then the second bullet point here in saying treat them like third parties, and really they should be on a need-to-know basis. So how do you balance those two? Certainly in most collaboration agreements, such as JVs, they typically do not spell out the very details of every party's trade secrets, but they may more generally refer to trade secrets by category, or certainly a general technical area. So for example, if you have a chemical process that embodies some trade secrets, such as a particular process condition, your agreement might refer more generally to the trade secrets or process that covers certain aspects. So what are some other ways for protecting and maintaining the trade secrets and what you should be expecting of your partner? Certainly physical security is one, and those are probably policies that you already have in place. Also this idea of limiting access, and not only on a need-to-know basis, but perhaps dividing up the individuals that have pieces of the information, for example, about a process, such that not all of the information is with one person, so it could be recreated. Also specifying, again, what should be done with the trade secret information at the conclusion of the research project. We'll look at a case in a moment as to how that can go wrong for those that maintain it, but certainly require the return and destruction of the information, any copies that may have been made. And with third-party suppliers, just because you have a JV, there may be third parties outside of that one partner of the JV wants to share the trade secrets too. Certainly have in your agreement that you have a requirement of prior approval by the other party prior to dissemination of any trade secrets. And then as yourself, you need to vet the third party for handling the confidential information, such that all parties that are getting access to your trade secrets are taking the same reasonable efforts that you have. So what types of things I said earlier that you need to monitor your partners, even during the joint venture and after? So where are some red flags that may come up on every side that particularly should catch your attention with respect to potential trade secret misappropriation, particularly if a deal falls through, and even if you do reach a deal, you do have a need to have some ongoing due diligence. Some examples of this includes when you have a partner that all of a sudden starts asking for more confidential information than you can see as reasonably necessary. And this came up in the Capu case, which I'll refer to, KG versus Diamond Imports, where basically they had this contact of particular customers. So KG and Diamond Imports had entered into an agreement to have a joint venture for wholesaling diamonds to retailers. And after the parties entered the agreement, KG told Diamond Imports that they needed to inspect a list of diamond importers' customers and prices because KG wished to ensure that Diamond Imports could deliver an experienced diamond seller. There was no real need that they could articulate as to why they wanted it, but they received it. And after KG had made the assurances that it would never contact the customers on the list without Diamond Importers' knowledge and consent, they shared it. And shortly after, Diamond Imports found that KG was directly contacting Diamond Importers' customers and offering to sell the diamond to them at prices undercutting, of course, Diamond Imports. So KG then basically repudiated the existence of the venture, and they went through a whole nasty set of things to kind of end the venture itself. But these are things to perhaps, don't be afraid to ask your partner if, in fact, they're wanting more confidential information, unless they can tie it. Again, it's this need-to-know basis. And even though there were assurances made here, they were violated. Similar competing technology that emerges all of a sudden after you have a failed joint venture is another example that should raise some red flags. In the Vesta case, Vesta and Amdocs had provided services to mobile phone networks and began working together in basically a strategic partnership where they were integrating their services and platforms. And here they were working on a joint proposal to supply a payment solution to yet another party, Metro PCS, and then that was going to be integrated into Amdoc's billing platform. Ultimately, when they made the pitch to Metro PCS, it was unsuccessful. And shortly after, Vesta learned that Amdocs offered Metro PCS an integrated payment solution and billing platform and basically cut out Vesta from the entire sale. Vesta then alleged that there was no way that Amdocs could have built this payment solution in such a short time frame without using some significant portion of the confidential information provided to Amdocs by Vesta in connections with this collaboration project. Ultimately, there was certainly a suit with respect to theft of trade secrets, among many other things, that was unsuccessful, again, because there was nothing specific that was pointed to with respect to the agreement and identifying the trade secrets that was being alleged. So the importance of having the understanding of where your trade secrets are, who owns it, what type of competitive advantage it provides is extremely important in these types of agreements. So finally, after the JV ends, what should you be doing? Certainly, former JV partners could be arguing that you had improper retention. So after a JV ends, review the provisions that are required for likely destruction of trade secret information. And this is what happened in the Welligix court, where they, again, awarded around $40 million in damages based on circumstantial evidence of improper use by the former collaborator. Just because you have it sitting around, it could be the basis of a trade secret misappropriation in some use that is in contrast to the agreement that you've reached. So how to prevent those? Certainly purge the collaborator's trade secrets and confirm destruction with them. So overall, it's very important to have a comprehensive agreement that contemplates trade secret sharing and protection throughout the life cycle. And due diligence, of course, starts before the agreement, as Krista had identified before, and continues even if no deal is reached, and certainly if a deal falls through, to continue to monitor those partners. So with that, I will pass it over to Charles to cover the next section, IP ownership considerations.
Thanks, Jen. So for IP ownership considerations, one main issue comes up that frequently people have a lot of questions about, and that is considering that collaborations will often result in new IP rights, whether patents, trade secrets, or know-how, during the course of the collaboration or joint venture. And so it's very important to decide in advance how to allocate those new IP rights. Absent an agreement, patents are jointly owned by their co-inventors. So where you have patents invented by technical personnel from more than one collaborator or JV partner, the presumption would be that the patents would be co-owned by the inventors, and likely they would be assigned to their respective companies. As a result, it's very common that collaboration agreements need to set out how joint inventions will be owned. And there are a few options, some of which, as we'll see, are perhaps attractive, but still less common than the straight joint ownership situation. The first option is that the parties can assign their rights in joint inventions to the JV itself. The JV would then own the IP and could license the patents to the parties so that they could use them in furtherance of the JV's goals. The second way is the parties can jointly own all IP that's created through the collaboration. This is probably the easiest way to do things up front because you don't have to decide how to allocate rights. But as we'll see later, it can cause some pretty tricky situations and conflicts when the collaboration ends. The third way is that one party or the other can own the IP created during the collaboration and license it to the JV and to the other partners. This may make a lot of sense in theory, but in practice it's often hard to achieve. And the key point of dispute is usually which company is going to own the IP and license it, and which company will simply be a licensee. So the parties think about this option, they decide it makes sense, and then they can't decide who's going to be the owner and who's going to be the licensee, and they revert to the joint ownership situation. Parties also need to bear in mind that joint IP usually involves aspects of one party's or both contributed IP, and thus a jointly owned invention might have substantial overlap with what a party brought to the table. That means that joint IP can result in a party who may be your competitor having IP rights that come pretty close to your own IP portfolio, even after the collaboration ends. There are definitely some perils of jointly owning patents created during a collaboration, and it's instructive to look at the U.S. Code section that governs joint ownership. So 35 U.S.C. Section 262 states that in the absence of an agreement to the contrary, each of the joint owners of a patent may make, use, offer to sell, or sell the patented invention within the United States or import it without the consent of and without accounting to the other owners. So what does that mean? Well, in the U.S., joint owners can practice the jointly owned patent. They can freely grant sublicenses to the jointly owned patent. They can also create new competitors via that licensing, which is really a change in the business situation. The other aspect of joint ownership that causes problems is that in the United States, you must join all joint owners in an enforcement suit. So you may have joint owners who don't want to enforce, and they may refuse to participate. So if your JV collaborator does that, they could just simply grant a sublicense or a covenant not to sue and thwart your efforts to enforce your jointly owned IP. Another key consideration here is that these rules differ from country to country. So you may have one situation in the United States and face a completely different enforcement regime in another country if your JV includes rights in that country. Despite these perils, as I said, it's quite common that parties are unable to agree to a better way to allocate ownership, and so they end up with joint ownership because it's the easiest at the time of signing the agreement. So what questions should you be asking if you're going to have a joint ownership situation? Well, one is, who's going to be in charge of prosecuting joint patents? Who's going to pay for the patent office fees? Who's going to pay the maintenance fees? Similarly, who's going to take the lead on asserting patents and deciding whether to sue? Who gets to control that infringement litigation? These are all things that should be specified in the agreement up front to avoid problems down the line. And last, what if one owner refuses to participate? What procedures do you have in place? For example, some best efforts clause where the parties are required to try to enforce against infringers, or at least a clause where the parties are required to cooperate if the other party wants to file suit. Similarly, there are a lot of questions to answer in terms of exploiting joint IP. Again, in the U.S., all co-owners can sublicense. So do you want to restrict the license or the sublicense to avoid creating competitors? An agreement should also set out whether the parties or the JV itself can further develop joint IP or make improvements to joint IP. The agreement should also specify whether a party is obligated to share licensing revenues with the other parties or with the JV itself. And finally, one question that comes up a lot is whether the parties to a JV can compete with the JV. In some cases, this isn't really a concern because their work is fairly separate from the purpose of the JV. But in other instances, what they're doing with the JV is very similar to the existing work that they already do, and therefore they may arguably be competing with the JV itself simply by doing what they've already been doing. One other aspect that I'd like to talk about is derivative IP and improvements to contributed IP. You know the perils of the joint inventorship and joint ownership situation, but these situations can also raise some risks. For example, derivative IP is IP that might be created during the joint venture, but is completely unrelated or at least ancillary to the JV's work. And disputes also arise, as we'll discuss in a moment, regarding improvements to a party's contributed IP. Those categories can be tricky because it can be very difficult to draw a line between IP that's related to the joint venture versus IP that is only ancillary. And so this highlights something that Krista said earlier, which is how important it is not only to define what the background IP is that's being contributed, but also the purpose and the scope of your collaboration. Really setting the mission for the joint venture or collaboration will prevent mission creep, which can lead to one collaborator believing that IP should be jointly held when really it was developed solely by the other collaborator. As for contributed IP improvements, parties typically want to retain their rights and may not want the other party to have rights after the collaboration ends. And so agreements will often specify that improvements to one party's IP will belong to that party or will revert to that party after the collaboration. As we'll see, however, even with some of these provisions in place, disputes can still come up. And a really good example in a recent case regarding how joint ownership issues can arise when a joint venture dissolves is the Roccat versus Solazyme case. In that case, the two companies formed a joint venture called Solazyme Roccat Nutritionals. which was designed to research and market microalgae nutritional products. After a while, the joint venture dissolved, and a dispute arose as to patents and trade secrets that had been created during the life of the JV and that were owned by the JV. Part of the dispute involved the fact that Roccat had apparently gone over to Europe and filed patent applications that were very similar to ones that had been filed in the U.S. and were owned by the joint venture, and so that caused a little bit of conflict between the parties, and so the case went to arbitration. At the arbitration, Roccat argued that the patents generated during the course of the collaboration and owned by the JV should be jointly owned because they reflected contributions from both parties. Solazyme disagreed. They argued that all of the JV's patent rights were actually improvements on their contributed IP and that therefore they should own them. Now, the JV agreement in this case stated quite clearly that upon dissolution, improvements to either party's IP would be assigned to that party. But one problem was that the JV agreement did not actually define the term improvements. And so the first step for the arbitration panel was that they actually had to go outside the scope of the joint venture agreement simply to define the term improvements, to decide who could own these rights. Well, in the end, the outcome here was not very good for Roccat. The arbitration panel decided that all of the IP, including the applications that Roccat had filed, should be owned by Solazyme. They heard testimony during the course of the arbitration from both parties' experts on the issue of where the improvements were and whose technology it was improving, and they credited Solazyme's expert that it was Solazyme's contributed IP that had been improved. So the result is Solazyme got all of the rights. Roccat objected to a lot of aspects of this. One aspect was that the arbitration panel relied on an outside agreement, a material transfer agreement, in construing who should get the rights under the joint venture. That material transfer agreement had basically stated that Roccat would be furnished with certain samples of the microalgae materials for their evaluation, but they agreed that Solazyme owned the samples and that Roccat would not file any patent applications directed to the material it received. In the end, this case was actually appealed to the Third Circuit, and the Third Circuit affirmed the ruling of the district court, which affirmed the arbitration panel. The Third Circuit said that Roccat did not previously possess any products which were in any way similar to those contributed by Solazyme and worked upon by the joint venture. So we're going to talk a little bit about anticipating the termination of the joint venture. And, that might not seem attractive at the start of something where you're hoping it will go well. But as we'll see, it's very important to plan for the termination of the collaboration right up front. As the Solazyme case demonstrates, it's really smart to do this up front because there's a number of different scenarios where the joint venture may end, ranging from the joint venture being really successful in achieving its goals to having one party decide that it's not going to achieve success and that they're going to leave, even breach by a partner or bankruptcy. And so it's important to allocate your IP rights following the termination and decide how those disputes that may arise will be handled. So a few key points to keep in mind with regard to termination. Your agreement should specify what happens to the IP upon dissolution. So if the joint venture itself held the IP rights instead of the joint ownership scenario, the agreement should specify things like, will the joint venture license the IP to both parties upon dissolution? Does the IP get assigned to only one party who gets all of it based on their contributions up front? For example, in the Solazyme case, you had each party getting its improvements, but in fact, Solazyme had contributed what ended up being the IP of the joint venture. And of course, you have a scenario that no one wanted to deal with up front that you thought you could put off, which is the joint ownership situation that comes back to haunt you. Some approaches that people will maybe use could be things like trying to divide it based on technology. For example, maybe you have a collaboration between a company that makes diesel fuel and a company that does research on engine technology, and you might structure your agreement so any new IP relating to diesel or fuels could go to the first company, and any new IP relating to engine technology could go to the other company. Of course, there's always IP that's not so easy to categorize, and so disputes will probably still arise. But at least in that instance, you've perhaps taken some of the disputes off of the table. But other questions come up in addition to just how to split the rights. For example, if the JV or collaboration is unsuccessful, can one party continue to do the work of the JV to try to achieve the goals of the JV on their own? And if they do that, is there anything that the other party has to do? For example, allow them to continue using the licensed patents, or maybe even assist them with granting licenses or making reasonable efforts to facilitate their work. Another question is one that Jen already addressed. You need to make sure that your obligations are clear for trade secrets. And again, that's not just on the side of protecting your trade secrets, but also, as in the Wallogic's case, making sure that you're living up to your obligations so you don't get sued down the road. It's very important to set out procedures for handling disputes to anticipate potential problems, and things you might want to think about are things like disagreement over terms and breach. And so this basically goes back to the considerations Krista discussed earlier, doing the work up front to know who your partner is, what changes that company may undergo during the course of your collaboration, and knowing what the goals of your collaboration are. There's a lot of options for resolving conflicts. At the point where you're in a conflict, you'd probably rather not be there, so the best thing is to avoid them. But if you do find yourself in a dispute, there are options ranging from establishing an internal IP committee within the joint venture to mediation and arbitration, all the way up to filing a lawsuit. And when you have those types of situations, it's very important to specify things like whether an arbitration is binding, the timing of the arbitration, what information the arbitration panel can consider, and also things like the choice of applicable law for any lawsuit, and accounting for differences in foreign or international law. For example, whether a country's own laws would trump the law that you've agreed on in your joint venture agreement. And again, some lessons learned from the Roccat Frere versus Solazyme case. As I mentioned, the parties there ended up in arbitration, and they went through part of the arbitration, but ended up disputing what powers the arbitration panel had. Roccat had filed 2 declaratory judgment actions that started the dispute in these cases. They argued that the arbitration panel had exceeded its authority, that they did not have the right to assign the patents to Solazyme, that they had gone over time, exceeded their time limit to make a decision, and that they had improperly considered information outside the joint venture agreement. All of those things were things that could have been specified up front in the agreement, but weren't, and were the basis of a lawsuit by Roccat. Parties disputed even whether Delaware law or the Federal Arbitration Act should govern. And so as we heard earlier, the district court, unfortunately for Roccat, upheld the arbitration panel's ruling in favor of Solazyme. And one really notable thing in this case was the Third Circuit, when it affirmed the district court, noted that the arbitration provision in the joint venture agreement was very broad. And so Roccat had faced a situation where it had gotten into something where a broad arbitration was applicable that it didn't like. And so this case is a great example of why it's important to set out these details in advance. And with that, that comes to the end of my slides on terminating. So we'll, I guess, move to some questions, Matt.
Yeah, thank you, Krista, Jen, and Charles. Before we begin the question and answer portion of our event, please take a moment to complete our brief evaluation survey. As we strive to provide programs of value and continually improve, we would appreciate your input, which will guide us in planning future programs. We will now address questions from the audience. As a reminder, to participate in the Q&A, just click on the Q&A button and type your question into the Q&A window, and then click Submit. Jen, our first question is for you. How should companies protect trade secrets in the oil and gas industry where everyone appears to trust their partners? Is trust the best measure?
Sure. I mean, trust is certainly important, and I completely can recognize it in the oil and gas industry. But I think, as you've probably gathered from the presentation today, that you need more than trust, actually, to ensure protection of trade secrets, just because the relationships that are forming with these joint ventures and potential joint ventures can change. And so in addition to that trust, I would recommend certainly a comprehensive joint venture agreement that covers the specific trade secrets, and when I say specific, I mean from a subject matter perspective, that you have identified as each party owns, what the value of that trade secret is, and certainly the reasonable efforts that both you and your potential partner are going to follow to continue to protect that trade secret. So some of the things we discussed today is fleshing out what each party needs to do before other third-party access may be given to trade secrets, the actual measures of the confidentiality agreement, and just making sure that your partner is providing the same level of security on an ongoing basis with respect to the trade secrets.
Thank you, Jen. Charles, this next question is for you. How should companies document results of the collaboration, including new inventions, particularly where inventors may be difficult to identify?
Sure. So just as in your own company, in a collaboration, it's very important to document new inventions and use best practices for identifying and documenting contributions by different people who worked on the invention. And that includes things like invention disclosure forms. Now, of course, the situation in a collaborative engagement can be a little bit more difficult. It can make it harder to identify inventors. For example, when people in both companies are doing similar work and it's unclear whether one or the other was the inventor or both. But the basics are essentially the same. You want to make sure you use good practices to document your inventions, and you hopefully will have a situation where you're including all of the inventors. I think your best case scenario is you get inventorship right, but you at least want to make sure that you don't have any people who contributed who are left off. So in addition to using good invention disclosure practices, I think it really reinforces the idea of documenting the IP that everyone contributes upfront to the joint venture. There are numerous cases, and the Solazyme case that I discussed earlier is one great example, where joint venture partners end up disputing whether an invention is a joint invention or instead stems only from one party's contributed IP. So having a clear definition of what came into the joint venture collaboration upfront can be very helpful in that regard.
Thanks, Charles. Krista, I have a question from the audience for you. What structures or procedures should be in place from an IP governance perspective to handle IP issues in the joint venture?
There are a number of options that you can include in the contract to help with IP governance. One option is, especially for joint IP or an improvement, if it's going to be joint IP, identifying one partner who may be responsible for certain decisions about the IP in the first instance or may control those decisions, such as prosecuting patent applications or deciding whether to assert the patent. However, you could also, if one party does have control, there's also other notices and collaboration provisions you can include in the agreement, such that to the extent a patent application is going to be filed, a draft of it needs to be sent to the other side so that the other party has a chance to contribute or weigh in on that. Same thing with what countries a patent application should be filed in. That often is a decision that even if one party has control or takes the lead in handling prosecution, the other party should be consulted. Same things, the parties should decide to the extent one party is taking the lead in obtaining the patent from the USPTO, what sorts of documents would need to be shared, what office actions should be shared, amendments, that sort of thing. So these are all things that can be addressed in the contract if the party that does not have control of prosecution or IP governance issue still wants to have a say. Also, another fairly common tool that people use in joint ventures is to have a committee to manage a host of different decisions, which could also include decisions about patent prosecution and litigation. Those committees within a joint venture are made up of members from each of the partners. And often, if the committee itself cannot decide on an issue, there could be provisions that say that the decision then would be referred to executives from the partners who would have the final say. Or even if you wanted to arbitration or mediation or one of the other mechanisms Charles talked about for potentially handling disputes.
Thank you, Krista. It looks like that's all the time that we have today. Thank you for attending today's webcast, How to Avoid Common IP Pitfalls in Energy Industry Joint Ventures and Collaborations. The presentation will be available on demand in the next week. Please look for an email from us with the access link. This concludes today's Finnegan webcast. We thank you for participating.